my God, I did that during recording.
Good morning, everyone. Welcome to Forms class today. After a Waffle Wednesday, which is always fun. Thank you to staff for making breakfast as usual. They do such a good job. If you see them, do thank them in person. I know they'll appreciate it. Today's form is the 22B. So we're definitely seeing more contingent offers in this market. And I know that a lot of people who are wanting to buy another house tend to have to sell a house in order to buy that house, right? Uh-oh. You get that, Hayden? Look at that, the fan's even popping up on the owl because it's making noise. But I'm gonna go ahead and share my screen. All right, hopefully everyone can see that. So buyer sale property contingency addendum to purchase and sale agreement. There's a lot of booby traps in this form. And I think that every time that we go through some market changes is when I usually get the most amount of phone calls with questions on this form, because it's being used more often and people forget it. And also there's some things in here, literally, it could, it literally could backfire on you. You could be waiving financing contingency on accident if you don't do certain things for the buyer. You could lose the deal. A seller could actually terminate. They could actually terminate on you and take a better offer, even though you actually have done things, when you think you've done them right. So this is one of those forms you really have to pay attention to some of these booby traps, and I'll try to point them out, and I'll tell some actual stories. Even a couple, I won't go over into the case law thing. If we have enough time, I might talk about some of the case law things that have happened with this. But the point is that this is it's a form that you really got to understand, and you're going to be experiencing this form in your career for sure. Who has already done a contingent deal this year already? Anybody? Yeah, you're about to.
Yeah.
You did do one already?
I'm gonna do one.
You will be, okay, perfect timing. Anybody in Zoom already had a contingent deal yet this year? Kind of surprised if it didn't. No? All right. Well, I will start things off. Obviously, this is the forms manual. Inside of all of the forms, on the left-hand side is the actual form itself. On the right-hand side is the forms manual on all of the inside information to the form. There is 10 times the amount of information and instructions in the manual than there is in the form itself. And so we always utilize the forms manual to really fully understand how to use it. All right, so use. This addendum is to be attached to a purchase and sale agreement when the sale is contingent on sale of buyer's property. Attach a copy to every copy of the purchase and sale agreement. Do you guys know what that means? What's that standard language mean?
So
do you know what that reminder is? What they're talking about is when you're sending offers and counter offers and things getting signed, you were supposed to be sending all of it. Like if someone sent you a deal, I sent it over to Hayden. I said, here you go, here's an offer. He's like, man, we love all of this. We're gonna sign all this around, but we want this one change. He sends it back to me, right? And then I get it and I'm like, oh, here's the one thing he needs. I do an initials and I send that one page back to him. You can't do that. You have to send all of it back. Why do they do that?
So I'm guessing there's no like loophole somewhere down the line, like, oh, this person didn't attach this to the offer, so it doesn't count. I'm guessing.
Well, there's definitely a standard of business practice. Your standard, business practice should be keeping it all, but the reason they do it is to avoid issues, changes. We have seen people, I've even seen this in my own career where we had sent over an offer. They sent it back and then they actually just marked the box in the same colored ink without initials, like the broker noticed something and then he marked it and sent it back and we didn't see it without changes. And then they tried to enforce it and we're like, well, wait a minute. We had to go in and prove it and it went to arbitration. And we had to show proof of our emails, proof of our communications and all this other stuff. So that's the main reason why that's in there. You are always supposed to send it all. So that's what this statement is. Do not use this form if the buyer has already entered into an agreement to sell buyer's property. Instead, use a Northwest MLS form 22Q, buyer's pending sale of property contingency addendum. So if the buyer has a house in Arizona and they have a contract accepted on it, are you using this form 22B when you're writing up a Washington house? No. Yeah, you've got to use a pending sale addendum, which is totally different. You can't be bumped in a 22Q, and there's a bunch of other things that goes along with it. B.
But you can be bumped on a 22B.
Yes, yep, and we're gonna go over all the ins and outs of this stuff. Property remains on the market when the sale is contingent on the sale of buyer's property. Seller's property remains on the market in the contingent status. That's the key thing. Seller may bump buyer. See general comments for MLS form number 44, the bump notice, and MLS form number 46, the bump response. Also read Northwest MLS bulletins explaining the contingencies. Alberto, you want to read C?
Contingency or condition, there is no legal difference between a contingency, condition, or subject to. However, in the local residential real estate practice, the term contingency means the property remains on the market until seller bumps buyer or the purchase and sale agreement terminates.
Yeah, so there's no difference in those words if people were to try to write it. We're in a competitive market. We talked about yesterday kind of in sales meeting about, fine tuning your skills, making a difference in this market, like you have got to do that. And that's exactly what we're doing in this class. D. Blaine, you want to read D? You can see it.
My language is pretty awful.
Oh, sorry.
I'll do my best.
All right, go for it.
Failure to list buyer's property. If buyer fails to list buyer's property for sale with a multiple listing service in the area, servicing buyer's property with a licensed real estate firm within 5 days after mutual acceptance, buyer waives this contingency. None that where buyer waives this contingency, buyer waives every other contingency in the purchase and sale agreement, including financial and inspection, and the closing date may be altered or accelerated.
Accelerated. Yep, good job. So yeah, I heard a wow in the audience. You screw up by not getting the property listed and active in the MLS within the default 5 days. So that's 5 business days. Remember, computation of time, 5 days or less, weekends and holidays don't count. So if it's not active, what happens? You just screwed your client. I mean, that's what it translates to, but yeah, I mean, they're waiving everything. They're like, all right, we had that probably about 2 year and a half ago or so. We had that in here. Our listing, buyer broker from a small company, they didn't understand. So you got it. There's the first huge booby trap. the listing, you know, like when you're gonna make that listing go live. You have to have it live in the MLS. So how long does it take to list a property? How long does it take you to list a property?
You could do it one day, but you need to have pictures.
You could.
5 days out, maybe. You have to make sure you have your prelim done with your title and escrow.
What else you need to do? You want a sign in the yard?
1A.
How long does it take to get a sign, a post in the yard?
3 days.
3 days, 4 days.
What else? I know.
Marketing, yeah, the marketing, so many of them.
1A signs.
Yeah, there's a lot to do, so
You should do before you make your offer.
there you go, bingo.
This is the same form that you use, even if you already list the property.
Correct, because what's the key thing that we read? Right,
They
like,
said first.
well, no,
5
what was
days.
it?
It's not pending sale, it's not under contract yet.
Not under contract. The buyer's house is not under contract yet. That's the key. Because that would be the key difference between this form and the 22Q pending sale. All right, so failure to sell or waive. Let's see, 11, you want to hit E?
Failure to sell or waive, buyer either fails to sell buyer's property or buyer fails to waive this contingency by the expiration of the contingency period. Then the purchase and sale agreement terminates and buyer is entitled to a refund of the purchase money.
Yeah, so there's a fail safe in the agreement that protects the buyer, that if the house doesn't sell, you know, they're not forced to move forward. They're not gonna lose their earnest money. I mean, it makes sense. You know, the lender here, they're telling you, we can't buy this other house until we sell our current home. There are a ton of people in this situation right now. A ton. Might be harder to go contingent in the frenzy markets, right? Because a seller doesn't have to wait. You know, I mean, that's really ultimately it. But there's a lot of other strategies you can do to get more business and to actually get a contingent deal accepted. Maybe off market, do off market letters. Every single time you guys have a buyer, don't forget, you should be implementing those off market. If you have a buyer, period, and you know the area in which they like, what is stopping you from marketing and farming that actual area? I heard is it 5? Well, I gotta think of the items. I'll say it's 5 right now. If I can't remember the last one, I'll put it out later, but there's 5 things if you can include in your letter that you'll have 10x the results basically for off-market letters. One is if you name the actual seller's name. So when you're writing the letter, it's naming their name. Next, it's I'm not looking to list your property. Next is you are naming your actual buyers, your client. So before you do these letters, you better get your buyer's permission. So we actually had a client fire our broker because they didn't get permission. They sent out the letters, and one of the letters went to someone like a relative, and they're like, "Hey, you guys are buying a house?" And they're like, how did you know that or whatever? Oh, we got this letter. So they were pissed because they didn't want their family to know. So we get their permission. So including buyer's name. Next is including the actual community's name. So don't just say, you know, dear homeowner, to whom it may concern. We're looking to buy in XY, you know, and we're looking to buy your house. We have buyers. Seller, like those letters are stale. Don't send those. And then the last but not least is, I told you I was gonna, this was the one I always like forget. Handwrite the envelopes. Handwrite envelopes. Don't machine stamp, you know, custom with the logos and all that crap.
You said 5,
Handwritten.
you said 5 and I wrote 4. Name actual seller's name,
Name.
not actually list I'm not looking to
So
list
list your
your property,
property
include actual community name.
and then include the actual buyer's name. Buyer's name, and then handwrite the letter. So if you do those 5, you have 10x results. One of our brokers in here, in our office, has already started to send, he's been sending a ton. He's already got like 5 deals lined up, and they're all million plus. And the crazy thing is that 2 of the sellers are like, this is perfect. Like, we really didn't want to open up our house. You know, they're still worried about COVID. And there's still people that are, that way. And so they felt most comfortable, and now they want him to find 2 houses for them. 1 seller. So that one, just one off-market deal could turn, just that one, it could be 3 deals. So, sorry, got a little sidetracked off the forms, but you guys have got to be taking these opportunities now, because this market is totally different. You do that, all of a sudden the buyer, like, maybe they don't like the house, but you make a connection. 70 to 74% of the first person that a client meets will work with you. The odds are in your favor. All right, I'm off my soapbox. All right, next is F. Abby, you wanna read F?
Seller's consent required.
Yep.
Buyer must obtain seller's written consent to any offer on the buyer's property that is itself contingent on the sale of the second property, contingent on the closing of a pending sale of the second property, or that requires closing less than 30 or more than 60 days after mutual acceptance of the offer on the buyer's property. If buyer accepts any of these types of offers without getting seller's written consent, then seller has the option to terminate the purchase and sale agreement. And if seller does so, buyer will forfeit the earnest money. Form 90L, buyer's request for seller's consent, contingent sale, can be used to secure seller's consent.
Okay, this is a biggie. A lot of people do not think about this one, because, they think, oh, great, we got our buyer's offer, accepted on their home, so now we can remove our contingency. But they failed to follow the rules to the form, and the seller can terminate on them. We had a top producer in our office, this happened to them. And I'll tell you the story of what happened. They wrote up a contingent deal. Let's say Alberto's the listing agent, and I'm the buyer's agent. And let's see, Abby's my buyer. Abby needs to sell her home in order to buy Alberto's client's house. So we get under contract, we use a 22B, we go contingent. We list Abby's property within the 5 days, it goes live, and in the first week, we get an offer. And it's a perfect offer. We're like, this is awesome. We sign it around. There was one change that was, one thing missing on that offer. So we had to counter it, because we couldn't just accept it. At the time it was written, the closing date for Abby's house was 30 days closing. That's a typical closing date, right? We sent that counter over to the other agent. The other agent's buyers couldn't sign off on it until the next day. How many days now is that? 29. So it just shortened because we didn't have mutual. The closing date went. See how this happened? So it took away a day. We got that and we sent it out. We went ahead and removed the contingency, sent the form. They immediately sent the 90L and terminated on us. We're like, whoa, wait, what happened? They're like, they had a much better offer. So even in that situation where you're thinking, oh, yeah, we got it. It's not contingent, because most people will get the one thing that they usually look at, and even the form itself is the seller's or buyer's request for seller's consent contingent sale. That's even the name of the form. But it's actually even for consent on if it's closing less than 30 days or closing greater than 60 days. And the reason that it's so important is because we're gonna go a little bit further when we start diving in deeper into the form. And you're gonna see that there's some things that default closing dates that's actually different than what you write on the front of the purchase and sale agreement. It supersedes it from the 22B. So there's some things that we're gonna have to dive in deeper for this to all kind of come together, but it's serious. Like, you gotta like really look at your dates and your times, and it's not just on the current deal you got accepted, the contingent deal, but it's when you're selling your client's home also. So you really gotta look at those dates and times and stuff like that. I guarantee you, without a doubt, if we reviewed Sky Slope and we went through all the contingent deals, how much you wanna bet there are actual offers in there that were accepted and they removed their contingencies and the closing dates were probably less than 30, and even the listing broker didn't even realize it and didn't even tell their seller, hey seller, it looks like they went ahead and accepted this offer without getting permission from you. Do you wanna still move forward? What do you guys think?
Had to do that in November.
You did?
Yeah.
For just to bump someone, or?
I was representing the listing
Mhm.
agent.
Yep.
And they were buying another property, so it got really hairy because that other property also had a contingency. So it was like 3 parties, and I was like, oh my God. And yeah, I had to disclose a lot of information because they had rights to see contract stuff and.
Yeah.
Yeah. It got hairy.
Yeah, so it can be quite complicated. All right, waiver of contingency. Let's see, Alberto, did you read that? You did, didn't you? Hayden, you read?
No, all good.
All right, go for it.
Contingency, if buyer waives the contingency unless the sale involves new construction, then buyer must close within 30 days of the waiver. If the sale involves new construction, buyer must close within 5 days from the issuance of a certificate of occupancy or 30 days of waiver, whichever is later. This could be the effect of accelerating the closing date because the closing provisions of this addendum control over the purchase and sale agreement. Moreover, buyers will have to close whether or not buyer can obtain financing. In other words, when buyer waives his contingency, buyer waives all other contingencies in the agreement, including financing and inspecting. Therefore, buyer must think very carefully about the consequences of waiving this contingency.
Yeah, so, waiving this contingency the first thing it's gonna do is accelerate the closing date. That'll make more sense when we get to the actual section. All right, H, buyer's property failure to close. Kristen, you wanna do H? Oh,
It's not moving.
sorry.
Buyer's property failure to close, buyer must notify seller within 2 days of learning that the sale of buyer's property has failed. If the sale of the buyer's property fails through no fault of buyer before expiration of the contingency period, the contingency shall be reinstated. There's a bag clear over there. And buyer has the opportunity to find another buyer for his property. On the other hand, if the sale of the buyer's property fails to close through no fault of buyer after expiration of the contingency period, then the transaction can be terminated and the earnest money refunded to buyer. Or buyer can elect to waive the contingency and in doing so waive all other contingencies in the agreement. This provision is for the protection of seller who should not have to wait until closing to find out the sale of buyer's property has failed. Form 90K, buyer's contingency property notice, can be used to provide seller with notice that the sale of the buyer's property has failed.
Okay, so there's another, booby trap. You end up having your buyer / seller, all of a sudden, like, you guys get in contract and you're moving along, and then that buyer seller basically gets their house, they get terminated on because maybe the inspection didn't go through or something like that, right? So now they gotta notify within how many days? Remember? Thread it. How many days do you have to notify the seller? 2. So you have 2 business days to notify the seller, otherwise what happens? You're waiving what contingency? All. Let's see, probably about 2-3 years ago, we had the same thing happen. Our listing. Buyer broker never notified us. They said, oh, we thought we had another buyer in the wind. That really wanted it. Come to find out that no, they can't buy. So we went ahead and we thought we were, trying to keep the deal together. So yeah, we gotta terminate. Well, wait a minute. When did the deal fall through? Oh, it was, almost 2 weeks ago. Well, it's waived. You just waived it. Yeah, but the appraisal also, the lender just notified us too. So then they were like, uh-oh, then they came back, well, the lender just notified us. The appraisal came in low. Does that even matter now?
No.
Cause that's waived too. Doesn't matter.
The financing on that?
Huh?
Where's the financing on
Waives
that?
everything.
Oh, wow.
And they have to keep your earnest money.
Yep, and we did. $10,000 to the seller. Yeah. In fact, actually, I do remember that one. The buyer got mad and then wanted to sue the seller. So they hired just a general attorney, and that general attorney said, sure, yeah, I'll work for you. And sent a letter. And then we had our seller go to a real estate attorney. And he sent another letter back, and he basically said, oh, please bring a lawsuit. I would love to be able to see you in court and to arbitrate this because I can't wait to win. I mean, it was like kind of short and sweet, like a letter like that. And then we heard crickets, nothing. Cause then he named, he basically used the form and broke it apart to the rules of the form and said, yeah, your client did not notify within the 2 days. They waived everything. They couldn't move forward. They're keeping the earnest money. End of story. So, yeah, $10,000. Goodbye. All right, so assistance in filling in the blanks, obviously, number 1, the date of the purchase sale agreement. The beauty about the forms manual is obviously every single one of the numbers tells you what the item is and what they're talking about. So you really, if you need help and you're like, I do not understand this, what do they mean about this? You can click it and then get to number 6. So just a little explanation. All right, the date of the agreement, buyer, sellers, names, who they are, the property address, deadline for sale of the buyer's property. Okay, so this is the first and foremost, the most important date. Insert the date that will be the deadline for buyer to sell buyer's property. The contingency period. If buyer is not sold before the end of the contingency period, the purchase and sale agreement terminates and buyer is entitled to the refund of the earnest money. So the first one is the date in which they have to sell, right? It's 45 days after mutual by default. So 45 days. That is how long they're saying that you have to what? Nope. To sell the property. And this is the part that's kind of confusing and why I'm asking this. When do you sell the property? When does it actually go under contract? I don't know. I mean, you're not going to know when that's going to happen until you get mutually accepted. So you have 45 days to get their house under contract. Because as long as it's under contract, when we read further, it's gonna kind of bring things back together and make more sense. So the first thing you have to do is find out, like, how long do you think it's really gonna take to get this deal together and to close it? You do have to understand, like, like, getting it under contract and closing it.
So then the pricing has to be really aggressive to be able to commit to that.
Yeah, so when you're having a consultation with those sellers and they, hey, we have to sell this home in order to go buy the next one. Right away, you're gonna know that your pricing is gonna have to be spot on. It's gonna have to be market price, right? You really are gonna have to make sure that you're pricing it accordingly. Maybe even aggressively, depending on if there's so much competition around you or what. It's all, I mean, obviously market dictates price and all that's gonna come together when you do your market analysis. So 45 days is about right because it takes maybe, hopefully 15 days. Right? Hopefully about 15 days or so to get a deal. And then, right, 30 days to close. So that's why they have it defaulted to 45 days. Why? Because I've seen on here like really short, like, okay, that's probably not a good idea. So 45 is the sweet spot. I would stick to that. Unless you know this thing's gonna go under contract in a day. You know, you're getting, you know, it's gonna be one of those fire sales, then maybe you could shorten it. But I would do no less than 30 for this. If you can get away with 60, that's amazing. Now you got 30 days to get it under contract, 30 days to close it. So it just depends. Okay, number 2 is when sellers consent to required on a sale buyer's property. We went over that. So this is the key thing. The 2 things that you need to get the seller's permission. One is is it contingent on the sale of closing of that second buyer's property? So if the buyer that's buying the home and they're going contingent, and if they need to sell their home in order to buy that home, and the next buyer that's trying to buy their home has to sell their home in order to buy your buyer's home to buy the other seller's home. If you have that situation, that's the first one you need the seller's permission to even accept an offer. If you go ahead and sign it off and accept it before you get seller's permission, what happens? Waive. You're waiving everything. Oh, also, seller has a right to terminate on you. That's the other thing. So seller can just say, bye, I got a better offer. And we had that happen to us. Next one is has a closing date less than 30 or more than 60 days from the date of mutual acceptance. From the date of mutual acceptance of the offer on the buyer's property. Remember the example, the story I said? That is why the seller had the right to walk. You do not want to make that phone call to your client. If buyer accepts any such offer without seller's prior written consent, seller shall have 3 days to terminate this agreement from buyer's notice that the contingency is satisfied. Which notice shall include a complete copy of the purchase and sale agreement for the sale of buyer's property, and upon seller's termination, buyer shall be in default and seller shall be entitled to remedies as provided for in the agreement. If seller does not timely terminate, the agreement shall not be affected. Remember what I was saying about the story about, I bet you in Sky Slope, there's a ton of these and neither brokers had any clue because they didn't pay attention to the timelines. So very, very important. So let's look at this other example. Like if the seller did terminate on you, what does that do to the other offer that your buyer seller, but the one that they accepted without permission? What happens to the other sale, you guys? What do you think? They're in a contract. It doesn't null and void their deal. So you have to think about that too. Yeah, now your seller's like, wait a minute, I'm selling where am I going? I have to sell my house now? Yeah. Yeah, who are they gonna be looking to on that one? I'm gonna need a hotel for 2 months, 6 months, an extended stay till I find a house. You're paying for it. I don't know, I mean, who knows what they're gonna ask you for? They may fire you. Because you didn't recognize the 1 day difference. Could they sue? You could sue anyone for anything, at any time, at anywhere, yeah.
You look at
Yeah, you looked at me funny, sue, yeah. So it's just serious business. Loan application, here's the next step. If this agreement is contingent on buyer obtaining financing pursuant to Form 22A, financing addendum, buyer shall make written application for the loans defined in Form 22A and pay the application fee if required for the subject property within, you got 2 check boxes. So the first one is within 5 days after mutual acceptance of this agreement, or within 5 days, if not filled in, after buyer satisfies the contingency in this addendum from mutual acceptance, if neither box is checked. If buyer is not required to apply for the loans until after satisfaction of this contingency, the timelines in Form 22A shall not begin until that time. This paragraph 3 supersedes the requirement for buyer's loan application in Form 22A. You're the listing broker. Which box do you want? You want line 28 or 29? What do you want? 28 or 29? You're a listing broker. You received this offer.
I believe he went the second.
Yeah. Right, this is 28.
You're a listing broker?
I can't read it.
Oh.
The one that says you make applications sooner.
Which one sooner? Line 28, listing brokers. You better pay attention to this. You got a deal, you get accepted for your seller, and they're like, oh, this is awesome. Yeah, you know what? I checked out their house. They're gold. Yeah, easy. They're gonna sell it easy. This is more money than you wanted. We could do this. Sign off on it, seller. You're down the road, they get a deal finally put together. Okay, I guess we'll make application now. Right? 2 weeks later, maybe 3 weeks later, they're like, yep, let's make that loan application. And then what's the lender say? Oh, man, no, you guys aren't gonna qualify. Now you gotta go back to your seller. Doesn't look like they qualify. You see all these like loopholes in this form? There's a lot of booby traps. I told you, this is one that definitely gets people.
Eric, I asked you probably about a month ago, that same question.
Yeah, you
I said,
did.
do you
Yeah,
make
that's right.
application or not? What happens, most lenders, if it's a contingent offer, right? I'm not gonna start with it. I have no idea this is gonna go through or not, right?
Mhm.
Typically, I'm actually, because once we pull credit or these other things, once you make an application, you have to make a decision on the loan within 30 days, right, by law. And so it's a lot of work to put it together, so I'm just not sure. Typically, we don't really work on it until we know that we're under contract and we have a closing date and we start hustling on it.
Right.
But if that box is checked and we have to make application means that we have to have all 5 elements of an application to go through, like an address, social security number, all that other stuff.
Is that the CIA?
Well, kind of, this one, if you have a property address, that's the one that typically makes an application.
Yeah,
And therefore, we need to disclose and all the other stuff
right.
when that happens. And so typically, if that second, that whatever the box that says you gotta wait, then I would probably wait. Because we either have them fully approved or not, it doesn't matter, but when it says application, that's when all the disclosures and everything have to come out. And so, but yeah, but if the lender doesn't check that, you know what I mean, if they take it, like any other normal application, you know, I assume you guys check to make sure the lender's actually made application, you know, made it so it's disclosable, and then if something
Right.
happens, you can back out, because you made an application in the period of time. So an application date is not the same thing as a pre-qualification. That's different. That's not these aren't applications.
Right.
Applications are when you have a property just, and then we have to dispose it by law. That's the application.
Yep. But you don't want them doing that weeks after mutual acceptance.
No, because we'd have it, either I would have it fully approved ahead of time, so it won't be an issue, and if we had to wait, then we'll wait, right? But I just think it's more incumbent on the lender to make sure that you make the application that period of time, because if you don't read that disclosure there. And the other one says you'll make application, but then in the regular financing says you'll make application with 5 days.
Right.
This one says you only got 2 or 3, right?
No, it's 5,
Is it
same.
5 on that one?
Yep.
Okay, or if they change it on, you don't see it, right?
Yeah.
So
Well,
that's-
remember, that's 5 defaulted. You could write any number in there you wanted. And that's something for, listing brokers pay attention to. They're saying, yeah, 20 days. They put 20 days in here, 21 days. I'm gonna put 21, match the 22A. No, you're not gonna want that. So just, you gotta, again, it's paying
Check with the
attention.
lender, just check with the lender, make sure they're making an application. That's-
Yep. All right, so we talked about the property remains on market. Don't ever let a listing broker tell you that, oh, yeah, well, we accepted your contingent offer, but we're leaving it active. We can do that. My seller can do that. Because the form says it could be active. It does say that. But what did it say? Do you guys remember in the beginning we read about the status? What does the status have to be in the MLS? What? It's contingent only, that's it, it's contingent. It's a contingent listing, I mean, it's contingent, that is the status. If you guys are searching, by default, when you go and you look for a house for your buyers, I hope you guys are doing this, instead of just only marking active properties, mark contingent. If your buyer doesn't have to sell a home in order to buy a home, you could potentially bump someone. I mean, the inventory is tight right now. You gotta do every little trick in the book to find your client more houses, right, to look at. So don't be scared. Look at the contingent ones too, because you could bump them. Questions about that? You guys are getting kind of quiet on me. Am I scaring you?
Well, what do you do if they try to say, no, we're gonna leave it active?
You tell them, I'm sorry, but you cannot do that. It's against the Northwest MLS rules. And it's a violation. Yeah, so if they say that, say, oh, no, I'm sorry, you can't do that. There's brokers who really think that you can. We had to go to their DB, and even the DB was like, well, yeah, they can do that. Like, no, they can't.
And
You
the
might
real-
want to call the Northwest MLS for some help.
The real life scenario on that one is somebody's buying brand new construction,
Oh, yeah.
wants to sell their house, and then somebody came in with an additional contingent offer
Oh,
to
yeah.
sell the house. It's actually happened. I've dealt with that, but a lot of times you'll get the new construction. That's kind of when it really happens. Is that you'll get a contingent on, because they're gonna sell their house. Somebody comes in and the chain goes down. A lot of times
Oh.
I find that scenario.
The most I've ever seen in my career was 5 houses. Chained. So let's talk about that actually. What are some things you think you could do to help make those transactions, 1, all close, and 2, make it easier on everybody? What's some things you might want to like set up that would help?
Communications with the lenders.
Yes.
Say it again,
That's what we
Jason.
were
Yeah.
saying.
First and foremost, you better get the same title in escrow, because it's gonna be chaos if you have multiple ones. Like down the line, like, hey, Chicago, hey, Fidelity, hey, Access Home Closing, can we get this to work together? So first and foremost, try to have the same title in escrow. That kind of goes for also your deal. If you're contingent, you're buying that seller's home, you gotta sell this house to buy this house. You might as well get all same titles in escrow. It will help things go smoother. And if you could get the same lenders, that would be absolutely amazing. Aaron wouldn't mind that. Throw him 5 houses, he'd be okay with that. That will help too, and then the third one, and it's probably the most important, is a communication line to everybody. All 5 of those houses did close too. That's crazy.
I was doing 3 and I was going crazy.
Yeah,
Oh my God.
yeah.
Three's pretty common.
So if you do that, that will help make things easier. Simultaneous closing is the one where, you know, that's the magic word, like, hey, can we simultaneously close that? And we're gonna get into the closing things and all this other stuff here coming up. But you can do that, but again, having the same title and escrow, communicating, and actually getting things. I mean, you really gotta be communicating big time when you're if you have a chain like that. You just gonna have to talk to everybody, get it all figured out to be able to line things up to make it happen. But yeah, that part can be a whole nother challenge of itself. Not, you know, not just closing them, but the simultaneous. So, all right, we did that one. Contingency satisfied. All right, we already talked about this. So seller has to give notice within 2 days of entering an agreement to sell the property. Contingent is satisfied. So you got 2 days to notify the seller once you actually get a deal, and you have to get permission for which 2 things? Seller's permission has to be granted for what 2 items?
If it's under 30-day close,
There's 2 things, under 30
and then over.
and over 60.
And then also if that, you know, offer is also gonna be contingent.
Right. So the 2 things are the timelines of either before 30 days or over 60. And don't forget, the time starts from, it said from mutual. From mutual.
Very important.
The very important words, right, Josh? Hey, I didn't say who did it.
Very confident.
I was very confidential about it. I didn't say who did it. I said a top producer.
It's a little bitter.
A little. And the other is contingent. I want that thing to stick in your brains because you miss those. You guys already know what happened. All right, buyer's property failure to close. So again, we talked about this. Buyer shall give notice to seller within 2 days of learning that the sale of buyer's property has failed. Such notice must be given regardless of whether buyer chooses to proceed with the agreement. I mean, if the buyer has to sell a home in order to buy a home, if it falls through, I really don't know how they're gonna do that. So let me tell you a story. I had a very experienced broker in Puyallup South Hill. Her family are new construction builders. They do custom homes. At the time, it's probably about, I don't know, probably like 2009 or 10-ish, somewhere in there. Probably get closer to 2010. Anyway, they had a house listed. Buyer came along, wrote an offer. They accepted the deals contingent upon that buyer selling their home. And at the time, the price was about $700,000 for this custom home. Back then, that's probably a 1.4, 1.5 now. Just to give you guys a little idea of like the type of a property. So the price that they accepted was under the price, and it was and this is the key, the earnest money was $1,000 at the time. This is what they accepted. What, is that a red flag? So they're moving along in the deal just fine. They haven't sold the home yet, still haven't sold the house. All of a sudden, another buyer, strong buyer from California comes in and says, we see your contingent, we love the house, we want the house, we're all cash, we can close in 2 weeks, 10 days, whatever you want. And we'll even give you 50,000 more. Above asking. And so what do you think they wanted to do?
Take that.
Of course they wanted to take that. So they wrote it up, they sent it, and then our experienced listing broker / builder said, oh, yep, we're gonna send the bump notice. What do you think happened? Well, What could the buyer do?
Waive all their contingencies forward.
Yep,
Waive all their contingencies and move forward, say, okay, we don't have to have any contingency,
Yeah.
and now you just sold the house twice, right? Or did you
Yeah.
not wait?
no, they wrote it, I mean, they did it right, they,
But
you
you
know,
lost
did the
out.
back, you know, they did the second buyer, yeah. You definitely have to use a second buyer addendum if you're signing that off, you know, for the second buyer. And then they gave the bump notice and that first buyer said, yep, we're waiving. And then, and our experienced listing broker slash builder was like, what? They can't do that? I'm like, yeah, they can. What's their risk? $1,000. They don't close, it's $1,000 out of their pocket. And she was pissed. I'm like, there's nothing you can do. There's nothing you can do. You accepted a low earnest money amount on this. So listing brokers, make sure you pay attention to how much the earnest money is, because that's what they're risking if they don't go through with the sale. Because they're like, I talked to the lender and they can't buy this house without selling. And what ended up happening, that actual buyer, they were freaking smart. They lowered the price. They sharply reduced the price on that. They got a buyer immediately. It was an all cash buyer. They closed it. They closed on time because their whole next plan was what? You're a listing broker and you're thinking like, oh, okay, I know how we'll get this. What do you think? What would you do in that situation?
Can't close on time.
Right, can't close on time. What would you do?
You don't have to extend,
Yeah,
failed to close.
there you go. Your seller's like, fine, we'll just wait for them to default and we'll close this right after. Don't worry, second buyer, we got this. We'll just wait till the next day, because you can't force either party to extend, period. Not a seller, not a buyer, either one. Buyer ended up closing on time. So they lost out like over, like 100,000 something more that they could have had. More than 100,000, actually, yeah. At that time. So you just got, I mean, all these little things matter. All right, waiver by buyer, there it is. Sale of buyer's property fails to close through no fault of buyer's expiration of the contingency period. Buyer shall have the option of waiving the contingency and proceeding with the agreement. Buyer waives a waiver of this contingency, also waives all the other conditions in the agreement, including financing or any other contingency. If buyer waives the contingency, the sale of the property shall close 30 days after the buyer's waiver. So they had 30 days once they waived it to close it. So yeah, plenty of time. Waiver for, by buyer on new construction. So the only real difference is, if at the time buyer's waiver, a certificate of occupancy, the CO, or its equivalent for the property has not been issued by the applicable government, authority, then buyer shall close within, it's defaulted to 5 days, if not filled in, of notice from seller that a certificate of occupancy or equivalent has been issued, or within 30 days of waiver, whichever is later. So if the new construction doesn't have its occupancy permit yet issued, then obviously they can't close on it and go and live in it yet. So that's the one key thing about new construction. Okay, so when you are writing up the listing, and let's look at this real quick. Because this is something that also will just screws people up and they don't understand. When you're writing up with a 22B for the contingent sale, what are you putting for a closing date? What are you guys writing? No, that's why I'm asking. You gotta know this. Do you guys remember how long is the contingency period by default?
45 days.
It's 45 days. So it's 45 days by default. So what's a good closing date you think you probably would have on the front page? At least 45 days. You're gonna wanna have at least 45 days. At least. But remember, you can't leave this blank. Right, for one, and I've seen this, it's just blank. You can't leave it blank. But remember, in the 22B, the closing date set forth in this addendum shall supersede the closing date set forth in the agreement. So it's always being superseded. Let's look at
So if you put, let me make sure I understand this. So if you put less than 45 days on the 21,
Mhm.
because 22B supersedes it,
Mhm.
if on 22B I put 45 days, then automatically that's an extension?
No, it's the timeline of when it has to close. It's gonna supersede, and there's multiple triggers that will change that closing date. We went through all the ones by default, like if you were to, screw up and you went to go waive it, it's basically you're closing 30 days from that waiver. Or what if you screwed up in the beginning and you didn't even list the property within the 5 business days? When's the closing date then? You guys remember? It's 30 days, right from when that's waived. Yeah. So I told you guys, this form's got so many traps in it. So many. So this is the thing. Let's see, let me go back to the closing dates on the other ones here. I put 30 for the other. Okay. Okay, so we're gonna look at the other forms and stuff first. So actually, yeah, let's look at that and then that'll help. That'll help actually clear that up. But let me look at the one more. Let's do a 3. Okay, so contingency satisfied. This is where it breaks it down. Okay. So buyer shall give notice to seller within 2 days of entering into an agreement to sell buyer's property. Oh, sure. An example, the contingency is satisfied. Buyer gives notice, or buyer's notice shall include a complete copy of the purchase and sale agreement for the sale of buyer's property. The sale of the property shall close 3 days after the closing of the sale of buyer's property. So that's when this contingent deal is going to be closing. So it supersedes whatever's written in the front of the contract. Okay, it's going to supersede. And now it's going to close by 3 days after the closing of your contingent buyer seller's deal. So the one you guys accept, that house, if it was closing in 30 days, that means you're closing on this one in 33 days. So it's gonna supersede whatever. You guys have questions about that one? That's the part that it just gets everybody. We had a broker last year call and complain, like their designated broker called and was complaining like, hey, it sounds like you guys aren't gonna close by the date, what's going on with this? So I go, let me pull it up in SkyScope, let me call my broker and we find out what's happening. Yeah, it's a contingent deal. And they were basing the actual closing date from what was written on the front of the contract. I'm like, you're contingent. He goes, yeah, I know. Yeah, here's the date. It supersedes by 3, it's gonna be 3 days after the closing of this sale. This sale doesn't even close for another 2 weeks.
So like if the closing's on the 15th and you close on the 15th.
Which closing?
The sale of the property shall close 3 days after the closing. So if the buyer's property closes on the 15th, so that new closing would be on the 18th. Because it's 3 days after.
Yes.
Okay.
Yeah. So it's gonna supersede that closing date, and it's 3 days. And remember,
Always that's communication.
yeah,
Like if you don't get anything from the seller broker, you should probably send something, say, oh, well, since we did this, this is gonna be our new closing date, so that you're communicating it, like from the very beginning, I would imagine.
yeah, you're definitely gonna wanna look at that. So you as the listing broker, and you're listing that seller's property, you accept a contingent deal. Then you have to and make the seller fully understand your closing date is gonna be 3 days after the closing date of that buyer's contingent property sale. So that's the part you really gotta watch, cause oh my gosh. We had one seller that was so mad, they moved out. The broker didn't do a good job of communicating, this was years ago, South Lake Union. They moved out of their house because they were following the front page of the deal, and here it was like, well, aren't we closing? Like, come on. And they're like, no, like, it's like the buyer's deal is closing in 2 more weeks, and then that's 3 days after that. They're like, oh, great, now we're not gonna have our money to close on our house. Yeah, so communication's gotta be, that level of communication's gotta be raised when you're in a contingent deal, just know that. Okay. Before I move on, does anyone else have any questions? Comments, anything? Cause that's the one that will get you. Guaranteed.
So the seller,
Yep,
since they're closing 3 days later, how common is it to get rent back?
there's no rent back, they're not closing.
But the seller's buying another property.
Maybe, I mean, it just depended on the
Let's assume
situation.
they are.
Okay, but if they are, their deal's not closing. There's no rent back, that's not past the closing date.
Okay, but the seller, the listing agent, okay, so you say I represent the listing. Now that listing is buying another property, who puts in a buyer's contingency offer.
Right? Well, actually, it'd be a contingent sale, it'd be a 22Q pending sale deal. But theirs is pending, it's under contract.
Okay, so it becomes hairy when you're accepting contingency, contingency purchase. And then you're doing also a contingency.
A pending sale deal too. But there's no need for a rent back or anything, because they're closing off, is just 3 days later.
But they're gonna need that money to buy
Right.
the next one. And so,
That's why the holy grail is a simultaneous closing. That's what you're trying to accomplish, because then you're closing that day, then those funds will be, available hopefully, and then they can go ahead and then transfer those funds right over to the other deal.
yeah,
And that's what you're trying to do, but it can be very difficult.
yeah,
That's why you always have to have a backup plan if it doesn't happen.
Because sometimes you're at the mercy of
Oh,
the recorder's office.
yeah,
that's true.
So
that too.
one has to record and you get numbers, then the other goes, the other goes. So even if it's simultaneous, you have to wait for the recorder's office.
Yeah,
Because one bank can't release the funds until it's legally into somebody else's hand. If they're doing it.
all right, so let's take a look at the 90K. So buyer's property sold, contingency satisfied. So this is, if you've got a contingent buyer and they actually get a deal accepted, this is where you're marking this first box, and buyer has accepted an offer to sell buyer's property. That is not contingent on the sale of closing, or excuse me, not contingent on the sale or closing of another property. And that will close no less than 30 days and no more than 60 days from the date buyer accepted the offer or is otherwise consented to by seller. For this notice to be effective, buyer must attach a copy of the complete purchase and sale agreement for the sale of buyer's property. If the sale of buyer's property fails to close, buyer must give notice to seller within 2 days as required by the buyer's sale of property contingency addendum form 22B. So that's the first box. You get a deal accepted, or you got a deal, on their house and you want to sign off. The first thing you're looking for is those 2 things, remember, A and B is it contingent? Right? Is it also a contingent deal sale, or is it closing before 30 days, or is it closing after 30 days? Can you accept a 22Q pending sale without the seller's permission? Yes or no? Pending sale. So
I would say, yeah.
my listing, you're writing up the listing, your buyer has to sell their home in order to buy my home. Another buyer wants to buy your buyer's home, and they're like, hey, I'm 22Q, I'm pending sale. Can he do that? Accept that without my permission? You don't think so? You guys thinking? Raise your hand if you think no.
Well, it's pending.
Raise your hand if you think yes. Yeah, you can. They can do that. It's a pending sale. It's not a contingent sale. So there's a difference in that. They've already got a deal accepted. Yeah. So failure to close and termination. So this form has a multi-use form, the 90K. So the next one is like failure to close and termination. Buyer hereby gives notice that the sale of buyer's property has failed or will fail to close. This agreement is terminated and the earnest money shall be refunded to buyer. Failure to close and reinstatement. So buyer hereby gives notice that the sale of buyer's property has failed or will fail to close. The contingency in buyer's sale of buyer's property contingency addendum form 22B is reinstated until the contingency period expires. How long is it by default for the contingency period to expire? How long is it? The contingency period? 45 days. If you were 30 days in and all of a sudden you gave notice the deal fell through. Dang it, buyer financing failed. Yeah, they can't close on my deal, that we can't move forward. How much time is left in the contingency period now?
15 days.
You got 15 more days to get a deal accepted again. Can the seller say no? No, they've already agreed to this. These terms are already agreed upon. So that timeline keeps going, right? If something happens in between it, it just all depends on, is the contingency period still intact? So you can do that. You can do that. You can have one deal, the buyer walks on inspection, go back on the market, get another deal, get it accepted, and now those timelines change and shift again, right? All based upon really those 3 things. When's the closing of the buyer sale? Because then you're closing 3 days later now, right? And the next is, how much time is left in the contingency period? I mean, that's really it, is how much time is left. You have that much time to get a deal accepted. All right, last is failure to close and waiver. So buyer hereby gives notice that the sale of buyer's property has failed or will fail to close. However, buyer waives the contingency in buyer's property sale of buyer's sale of property contingency addendum form 22B. Buyer understands that by waiving this contingency, buyer waives all other contingencies in the agreement, including inspection, financing, etc. I wish they would have put appraisal in here too, because that's the one that, like, that's a big one, and they don't quite, maybe they don't understand, but it'd be nice to say that.
It does say all.
Yeah, I know. But it's just a little bit more, oh man, you sure you want to waive this? That means you're paying whatever that value is, comes in 100 grand low, you're bringing in another 100 grand to close it. And then last is waiver. Buyer has not accepted an offer to sell buyer's property. However, buyer waives the contingency in buyer sale of property contingency addendum form 22B. Buyer understands by waiving this contingency, buyer waives all other contingencies in the agreement, including inspection, financing, etc.
Is that what the other person did in the story?
Yeah, that's exactly what happened in that story I told you about, the experienced listing broker / builder. That's what they did. They had no deal. And they just went ahead and waived it. So here's the seller's responses. Is seller's notice, first buyer's contingency satisfied or waived? Seller hereby gives notice to second buyer that first buyer responded to the bump notice and satisfied or waived first buyer's sale of property contingency. The second sale agreement is terminated and the earnest money shall be refunded to second buyer. Seller's notice, first buyer terminated prior to sale. Seller hereby gives notice to second buyer that first buyer responded to the bump notice by terminating the prior sale. The second sale agreement shall proceed to closing. So there's what would happen in that instance. So let's go back to this one, because we need to look at this one. And this is an important one. Tony, you want to read for?
Property remains on the market. Seller may keep the property on the market in the contingent status until seller has received notice that buyers has satisfied or waived this contingency. If prior to that time, seller accepts another offer, seller shall give notice to the buyer and shall give buyer X days, 5 if not filled in, or by the expiration of the contingency in paragraph 1, whichever is earlier, the above period, to waive or satisfy this contingency. If the buyer does not timely waive or satisfy this contingency, this agreement shall terminate and the earnest money shall be refunded to the buyer. Seller's notice shall be on the bump notice form 44 or similar form, and the buyer shall be on the bump reply form 46 or similar form. Buyer's waiver of this contingency also waives all other conditions in this agreement, including financing or any other contingency. If the buyer waives this contingency, the sale of the property shall close 30 days after buyer's waiver.
Okay, we have to talk about the bump period. By default, this is 5 days. 5 business days. So listing brokers. You list your seller's property and they all of a sudden, here comes a contingent deal. And they write everything at default. What could happen in 5? Really, you're looking at probably 7 days, right? Depending on when they issue this. So more than likely, you're looking at 7 full days. In 7 days, they could get a deal. Could they not? So they could end up satisfying the contingency. You might have a much better offer in hand. So how much bump notice would you really want to see in this box? Listing brokers? 1 day? I like that one. What would you put? I would not have more than 2. Listing brokers, don't let this be defaulted to 5 days.
If you have a better offer.
No, it doesn't matter. Like, remember, you're looking at getting this mutually accepted for your seller. They're not gonna be able to change it if a better offer comes along. Even if a better offer does come along, what can the buyer do? They can waive it. They can waive and move forward. Doesn't matter. So once you're in contract and you're accepting one of these, you have to understand that. One of the craziest things ever, Jesse Meisner had a deal and he's like, he called me, he's like, Eric, man, I wrote a deal for my client. We're contingent. And the listing broker just told me the bump period is 60 days. 60 days for a bump. Why would they do that? And I started cracking up. Why would you think someone would have a 60-day bump? Can you think of why?
They have an overpriced property.
They have an overpriced property? No. What? Why would a seller even accept that? You could.
Somebody overseas?
No. It's kind of tricky. Jim, do you know? No,
New construction.
no, that's a good guess though. The bump period,
To keep
The guy will pay
marketing.
for that.
huh?
The buyer will pay for that.
No.
Keep marketing.
Who helped accept that deal? Or who's accepting that deal? I mean, really, the seller, but who represents the seller? Listing agent. Would a listing agent want to see a super long bump? He double-ended the deal. He double-ended the deal. He didn't want anybody to come along and bump him away. I started laughing like soon as I said, I go, oh, he freaking double-ended it, dude. And he's like, what? I go, ask him. And sure enough, yeah, he represented the buyer. So listing brokers do not have more than 2 days. 2 is a max, 1 or 2. Because you have to be able to have, because if you're bumping someone, that means there's probably 2 reasons. It's either 1, they're not contingent. You're not gonna wanna bump a contingent deal for a contingent deal. You could. Huh? It's a higher price. More than likely, you got a much better deal for your seller. So you're gonna want this to be short. So please, 1 or 2 days. Buyer brokers, try to get 5. 6. No, keep it 5 because then you probably get 7 anyway. So all depends on who you represent. If that listing broker doesn't say anything, you got a much better deal for your buyer, because now you got, it's probably up to 7 days. Aaron?
So if the buyer, if the buyer says, look, I will waive my contingency, does that waive all contingencies in the contract?
Yes. If they're going in contingent and they're waiving, then yeah, they're waiving everything. Appraisal, but it all depends on what they're risking.
Like in terms of earnest money?
Right.
Oh, yeah, I mean, so if you're gonna write a contingent offer, you're gonna do it a large, I would think you would have to do a large earnest money.
As a listing broker, you wanna see it sting for them to
Yeah.
waive stuff. And you wanna make sure the bump is short, so then they're like, we got two business days to figure out if we wanna move forward on this. Most of the time they fold, if they're like, yeah, we don't got a deal.
But that's killer though, because I'm just thinking like, really bad for the buyer, because I'm getting financing on my own, I mean, just from the lender's perspective.
You're like, yeah, I'm sure the lenders
You're
like
telling me
not
a guy
stoked on
here,
this.
You haven't been, you know what I mean, like, you haven't got the appraisal back, everything else, we haven't really ordered the appraisal, because we weren't sure.
Yeah,
The house isn't filled with contingency just yet,
I know.
now you're gonna waive everything, that's.
Did you pivot to a bridge loan or something in case like that, where they could waive?
I mean, you would have to find another loan program, yeah, you should, whatever loan.
You probably have to pivot and do something else, maybe.
Yeah.
Represent the seller.
So really be careful on that one. Now let's look at the 46 and 44 before we wrap stuff up.
And that was 140, which one was that?
90K.
What we were just looking at? 90Q?
90K,
Okay.
yep. So 44. We need to look at this one. So that's first one is the bump notice. So notice that seller has accepted another offer. Listing brokers do not sign around another offer without the second buyer's addendum. Otherwise, you have what? You've sold your seller's home twice. That is the fastest way to a lawsuit. And we have seen that.
Repeat that again?
Do not sell your seller's home twice.
Well, how is it that I'm supposed to?
Hold on, well. I got some attention in that one.
Yeah.
There's a form for that. There's a form for that. So when listing brokers, when you have a contingent deal accepted with the 22B, you can't bump on 22Qs pending sale. So this is 22B, right? Or this could be any other deal. Actually, I mean, technically, you could sign off on another deal but only if you have the second buyer's addendum or the backup buyer's addendum. Those, it has to be one of those other forms. If you're contingent, you have to use the second buyer's addendum. So when you as a listing broker, you've got a contract accepted, it's contingent, 22B, right? Now, if you found a better offer and they're making another offer, your seller can sign around the deal with that addendum. You have to have that addendum. If you don't, you've sold it 2 times. The second buyer's addendum.
You know what number is that?
What is it? 9?
39.
39, that's it. 38, 39 are the two.
Bring it up.
Yeah. Yeah. So right here. Second buyer's addendum. Property subject to prior contingent sale. Second buyer acknowledges that the property is subject to a prior purchase sale agreement, the prior sale between seller and your name and the first buyer. Prior sale is contingent on first buyer entering into an agreement for the sale of the first buyer's property on or before. Prior sale provides if seller accepts another offer to sell the property, then the notice of seller's acceptance of a second offer shall be given to first buyer, and that's the bump notice. If after receipt of the bump notice, first buyer does not give timely notice that first buyer has sold buyer's property, or that first buyer waives the buyer's sale of property contingency, then the prior sale will terminate and this second sale agreement shall proceed to closing. Seller shall not amend the terms of the prior sale after mutual acceptance and prior to termination of the second sale agreement. So there's other stuff in here about the waivers, second buyer's waiver of contingencies. You're gonna wanna have a bunch of stuff done. We had this just, I don't know, probably about, I think it was like November. I think we had this in here, literally like, we got another, the second buyer is better. And, they don't want to do an inspection until they get moved into the first position. Do you think that's a good idea? Listing brokers?
They don't wanna move into the inspection.
They don't want to do the inspection until they get moved into first position.
Yeah.
You as a listing broker, you would want that?
No.
You're gonna kick away a current deal you've got in contract? That's even if it's contingent. I mean, they could end up walking on you from an inspection.
Yeah.
17, they can walk.
Yeah. 10-day verification period, they could walk on. I mean, there's a bunch, neighborhood review or whatever else, that's any of those other contingencies.
3 walks
Mm-hmm,
on the second deal before you accept.
yeah. So just really be careful about that one.
So if I remember correctly, when you're a listing agent and you're gonna move it, let's say you have an offer.
Mhm.
And typically, let's say it's, one that waives inspection and therefore you would typically move to pending status, right?
You're talking a non-contingent deal,
A non-contingent deal.
okay?
Now, if I remember correctly, if you want the seller to still have the right to bump that offer,
They can't bump a
then
deal,
they have to do this form first.
no. See, your whole story, you started out that they're not contingent. You can't just bump somebody. A seller can't bump someone.
It has to be.
It has to be contingent only. So you, in your case, you would just use a straight up 38A backup to the purchase and sale. That'd be a backup
I can
offer.
back up with them. Okay, got it.
No,
Now I understand. But I mixed.
no
it.
bump, yeah, with a backup. It's a second buyer's addendum for contingent only. And I've seen that. We've seen someone try to bump us and like, you can't bump us.
So so if you have a backup offer,
Yes,
you still need this one?
this is the backup offer, backup addendum.
Okay. But you have to kind of say it up front that you're gonna have a set backup offers?
You don't have to. I mean, it's probably a good idea. You would want that other broker to know that you've got a backup, huh?
Yeah,
Because what would they probably do?
Try to get it done.
hustle.
They're gonna hustle. They're gonna be like, hey, we're not asking for any items on this inspection. You guys got a backup. So yeah, there's a lot of
But I'm
differences
just
in
thinking
that one.
about when you change it in the MLS, that you see sometimes, okay, backup offers accepted, that I thought. that-
Requested.
Requested, thank you, that you have to say it up front.
Don't
you're
have to
gonna
say it.
move From active to pending to backup. Offer
Backup requested. You don't have to say anything, but. Okay, so two things in that question. The one is, first and foremost, you can't even change the status in the MLS without the seller's consent. They have to sign off on a Form 19 to say they want to have backups. You have to do that. And if you're the listing broker and you just do that, you don't communicate that to the buyer broker, how does that make you feel? How does that make you, the buyer broker, feel, and the buyer? What the hell? We're performing. What are you guys doing? So you better be careful. I've seen deals blow up from just that. Like, we're walking. We're not, screw it. We're terminating on inspection. Goodbye. Seller called and complained to us on one deal even. We were the buyer broker. We walked. That seller called our office and said, what happened? Why did you guys walk? We're like, what do you mean? You were accepting backups. And then she's like, I didn't say to do that. I don't understand what happened. I thought the deal was going along fine, and like, no, we had a right to terminate. And we used it because our buyer felt like we couldn't move forward because we knew there were things that were wrong with the house just by visual inspection. And we knew that we weren't gonna be able to ask for anything because you wanted a backup. And then she said, I never wanted that. I never authorized that. But we were like, well, you're gonna have to talk to your agent because we're done. So you don't do that. That will backfire on you. So you better communicate that. Big difference on those, whether or not you can even do backups, but just don't sell a home twice. I've seen that, gosh, multiple times. Because just brokers, they just don't understand the forms. All right, bump period, we talked that. The last one we got to do is the 46. Look at how many forms are connected to this form alone. Isn't it crazy? So let's look at the 46. This is the bump reply. This is the last one before we wrap it up. All right, so the bump response, in response to notice that seller has accepted another offer to purchase the property. The bump notice, buyer gives notice as follows. Buyer's property sold, contingency satisfied. So they may have already accepted, remember what I said for that bump period? They have how many days to respond? This is the form buyer brokers you're using to send back and to respond with.
That's 5 days, right?
That's 5 days by default. Your listing brokers, you want 1 or 2 days in there. That's it. Because otherwise, wait 7 days, they might have got a deal accepted over the weekend. They lowered the price, all of a sudden, boom, they get an offer accepted. Now they're sending this, and there goes bye-bye to your much higher offer for your seller. And better terms, probably. Okay, so buyers accepted an offer, buyers offered to sell buyer's property that is not contingent on the sale or closing of another property, and that will close no less than 30 days and no more than 60 days from the date buyer accepted the offer. That's the key thing. Or as otherwise consented to by seller. For this notice to be effective, buyer shall attach a copy of the complete purchase and sale agreement for the sale of buyer's property. If the sale of buyer's property fails to close, the buyer will give notice to seller within 2 days as required by the buyer's sale of the property contingency addendum form 22B. Next one is buyer's property not sold, contingency waived. Buyer has not accepted an offer to sell buyer's property. However, buyer waives the contingency and buyer's sale of property contingency addendum form 22B. Buyer understands by waiving this contingency. Buyer waives all other contingencies in the agreement, including inspection, financing, etc. And then the very last one is buyer's property not sold, agreement terminated. Buyer has not accepted an offer to sell buyer's property. The agreement is terminated and the earnest money shall be refunded to buyer. So that's the last one that connects to all the dots. 2, the 22B. It's an easy one, huh, guys? Paula's like, yep. Christian's like, questions? All right, get out there and not get sued. Thank you guys for making it. We will see you on the next one.
That was a hard one.
I'm gonna read all of